In the previous videos relating to place of supply, we finished checking out the situation when supply of goods is involved. Now we are going to check out the situation for supply of services, starting with domestic supply of services. How do you know whether it's domestic or not? If the location of supplier and the recipient is in India, then it's treated as domestic. If location of either supplier or recipient is outside India, then one leg is international. And that's the bifurcation. We are going to first start with the domestic, where location of supplier and recipient both are in India. We'll first check out the general rule for place of supply of services. Remember, the underlying principle of GST is destination based consumption, place of the receiver, and that's what follows in the general rule. It is divided into two, where the recipient is registered and where the recipient is not registered. In case the recipient is registered with GST authority, then the place of supply simply will be the location of service recipient. Simple logic, destination based consumption. In the previous module relating to registration, we've checked out what the location of supplier or service is. The same location, the same principles stand true for the location of recipient of service. It can be any of the three places. First, the recipient's place of business for which he has obtained registration, simply put as the place of business. Second, a place other than a place of registered business, a fixed establishment from where supply is made or from where supply is received. In the absence of the above two places, the usual place of residence of the recipient. In case of corporates, it could be the place where the company is incorporated. In case of an individual, his home where he resides. Same principles as location of supplier of services. So that's the location of recipient of services. In case of registered recipient, that's the general rule for place of supply. Now in case of non-registered recipient, why is this split made? Basically, it's more difficult to track a non-registered recipient because the GST tax authority has no documents or whereabout knowledge of this person. Therefore, the place of supply in the case of a non-registered recipient of services would be, first, if the address of the recipient of services is on record of the supplier of service, then the place of supply would be that address on record. If no such address is on record, then the place of supplier of services would be the place of supply. This is an exception case where the destination-based consumption principle has been overturned because the GST authority does not know the location of the recipient because he's a non-registered recipient. Now we know what location of supplier of services is. Place of business, fixed establishment or usual place of residence, and we've discussed all three in detail earlier. That was the general rule relating to place of supply of services. This separation of registered and non-registered recipient can be called as the hybrid rule because it's already difficult to track services as it's intangible. The government has concluded that this approach would be feasible, and that's why the hybrid rule has been introduced: registered recipient and non-registered recipient. Now, to this general rule, there are exceptions. There are nearly 17-18 exceptions noted down in law. What we've done is we've tried to categorize them to some common identifying trait. We found 6 common traits. The first one, immovable property, boat or vessel. Second, that these exceptions are related to an event. Third, related to transportation. Fourth, restaurant, catering, fitness or health related. Fifth, training or appraisal. And sixth, telecommunication services. What we'll do is we'll check out all the exceptions within these 6 categories that we have formulated to make it easier to understand the exceptions. Let's start our discussion with immovable property or boat or vessel, anything related to that. This category includes services which are 1. Directly in relation to an immovable property, which could include services of an architect, interior decorator, surveyors, engineers, or any other related experts, estate agents, or if it's service provided by way of grant of right to use the immovable property or for carrying out coordination or construction work. So anything related to an immovable property, architect, interiors, right to use the immovable property, all of it is included. Second, these services are by way of lodging accommodation. So it's an lodging service that is provided either by a hotel, inn, guest house, homestay, club, campsite, whatever name. The service that we are talking about is a lodging accommodation service. And note that even houseboats or vessels are included in this. It need not just be something on land. If a ship or a houseboat is providing lodging accommodation, then that will also be included here. Third, if the service is by way of accommodation in any immovable property or organizing any marriage or reception or any function, whether official, social, cultural, religious, or even business functions, any function related accommodation in any immovable property. Now, remember, this is different from lodging accommodation. In lodging, you would provide a room, sleepover, bed, breakfast kind of service. Whereas the third category is talking more of a banquet hall kind of services. There's accommodation for a short period during the day, and it's not a bed and breakfast service. And fourth is any service which is ancillary to any of the three services that we've talked about earlier. For all of these services, the place of supply would be the location of the immovable property or the boat or vessel. Wherever these are located, that will be the place of supply. What if the immovable property or boat or vessel are located outside India, outside the Indian territory where GST authority is not applicable? Then, in such a case, the place of supply would be the location of the recipient. Now, there is one more asterisk. If the immovable property or boat or vessel is located in more than one state, if it's in the border of two states, then the supply of service shall be treated as made in each state in proportion to the value of service which is separately collected or determined as per the contract or agreement. In the absence of such contract or agreement, then a reasonable basis would be prescribed by the government on that behalf. So if it's in two states, then you check the contract, you see what is the proportion of division between these two states and take the place of supply for each portion to be the state where it relates to. If there's nothing of that sort in the agreement, then wait, the government will prescribe a basis for you to determine the division. So that was the place of supply of services related to immovable property or boat or vessel. Location of the property or boat or vessel would be the place of supply with the asterisks for the two conditions that we've discussed in detail. We'll check out the provisions relating to all the other 5 categories in the next video. We'll continue our discussion in the next video.